It is important because it provides, for the first time, a scalable and operational certification mechanism that can support not only compliance within the EU, but also trusted international data transfers. It strengthens legal certainty, trust in cross-border data flows, and contributes to a more current global data protection framework in line with the GDPR objectives. It changes the landscape by making certification a practical tool for international transfers, not just a compliance label. Until now, certifications under Article 42 were mainly seen as accountability tools. With this development, certification becomes also a transfer mechanism under Article 46, offering an additional options alongside existing tools. This mechanism allows organizations to rely on a certification scheme combined with binding and enforceable commitments to ensure that personal data transferred outside the EU is protected at a level essentially equivalent to that guaranteed within the European Union. In practice, the certification verifies that appropriate safeguards are implemented and the commitments ensure legal enforceability, which is a key requirement under the Article 46 of the GDPR. Article 42 certifications is a voluntary tool to demonstrate GDPR compliance within processing activities like accountability, transparency, trust. And Article 46 certifications is a certifications used specifically as a legal basis for international data transfers, ensuring appropriate safeguards for transfer to third countries. So the key difference is purpose. Compliance tools on one side versus a transfer mechanism compliance on the other side. The main differences are standard contractual clauses is a contractual tool based on predefined clauses between exporter and importer. A certification is a third-party verified mechanism assessing compliance against a structured set of criteria, also taking into account the exporter and importer roles with ongoing monitoring. So certification introduces independent validation, operational assessment, potentially more scalability across multiple partners. So certification is more systemic and structured, while SCCs are more contractual and bilateral. GDPR certifications can only be delivered by accredited certification bodies. So they must be approved by national accreditation bodies or in some countries by the Data Protection Authority and meet strict requirements in terms of independence, expertise, and reliability. So there is a strong governance framework behind it. We can consider several strong benefits. So the first one, demonstrate compliance in a credible and transparent way, enhance trust with customer, partners, regulators, facilitate international data transfers, create competitive advantage in the market, structure internal governance, and improve data protection maturity. So in some cases, it can also become a competitive advantage to get certified. I would say start with the first advice, which is to start with a clear objective. So ensure compliance for data processings or ensure compliance for international data transfer or both. Assess your maturity level before engaging in certification. And see certification not as a one-off exercise, but as part of a continuous compliance strategy. And importantly, engage early with qualified expert or certification bodies to understand the scope and expectation of the certification that you want to achieve.